Hello, welcome in to our webinar. We'll allow a few minutes for people to log in here. All right, well, we will get started with an introduction here. My name is Dan Brewer. I'm the Vice President of Sales here at Advanced Staff HR, and today we'll be discussing a variety of relevant topics to us today, but really how the new administration is reshaping labor laws, various court rulings, policies, and of course human resource compliance. Our featured guest speaker is Advanced Staff's own Rebecca Woods, and she is our Senior Director of Human Resources here. And Becky comes with a lot of real relevant experience, which has made her, a keynote speaker on these topics and many more. She comes with 25 years plus experience in human resources and really helping address and shape mid-size to large-scale businesses and serving the employees within. So we're super fortunate to not only have her with Advanced Staff, but also hosting and being the main contributor today.
Good morning.
Morning, Becky. All right. Well, before we get started, I'll take you through some housekeeping items. We'll send, and we are recording, and we'll send this and other resources right after the webinar. And we definitely welcome questions. And so please drop them in the question box and we'll answer them to the best of our abilities at the end of the presentation. Those are always very valuable times for us when we do those. So we're excited for that. And obviously, hey, if we're unable to get to all the questions in the webinar, we'll follow up with a Q&A email afterwards and also provide an avenue where you can get questions and other things answered as well. All right. And then so our lineup and kind of our agenda will be the following. So, it's a new day and there's new rules. We'll have some basic definitions. We'll talk about some of these executive orders and their impact on employers. We'll talk labor law related actions and outcomes, the labor law changes affecting non-union and union employers. We'll talk about some immigration related actions, and then we'll have some key action items. And then, of course, like I mentioned, that question and answer session at the end. And, obviously, hey, we want to make it very clear that today we're here to talk about and get a factual understanding of the current topics that we are forced to address as owners, as employers and employees. And our number one goal is to really foster an educational discussion. And we definitely ask for an open-minded participation and really want it to be expressly noted that we have no affiliation or no guided hand when talking about these topics. I've been a part of this industry for 20 years and have had obviously changes in administrations, and with that has come a variety of changes, and it's imperative that we always stay informed and ready to execute. And so we definitely wanted to add that piece of it today. So with that, I will turn it over to Becky, and we'll get started.
Okay, thanks, Dan. Appreciate it.
You bet.
And thanks everyone for coming on board today. Really appreciate whether you're morning or afternoon or right near noon. We're happy to have you here. So we want to start out with, it is a new day and new rules, but it's not unusual. As everyone probably recognizes, every 4 years we have at least new rules and some extremely new rules that come through, or new interpretations or changes to existing. So as we begin this, every new administration has policies that they want to put forward. And one of the ways that they do that is through the executive branch and the use of federal agencies by rolling out policy changes and or new policies to begin with. Most of you probably recognize that some of these things and the changes that are occurring right now have been many years in the making. It's pretty obvious that there's been a lot of planning, and these things are being put into action. Probably could not have been put into action so quickly without those years of planning. But this was a unique circumstance with an administration that had already governed for 4 years prior, had 4 years more to think about it, and is now engaging in the next 4-year stretch. There will be an impact on your business if you have a business, and there may be some impact on employment as well. Everything depends upon what type of business you're in and which policies have changed or will be interpreted differently, but they could affect anything: your hiring, wages, workplace regulations, compliance requirements, all sorts of things. As we go through this today, I will try to stick to the changes that will impact in employment. There are many, many other changes going on that have other types of impacts unrelated to employment, and I don't have any intention of covering those. As everyone recognizes, there have just been so many executive orders and so many changes that have been rolled out within the last few weeks that it would be impossible to cover everything. We will begin with employment. But before we do that, I want to just take a minute to talk about a basic definition. And it's no intent to insult anyone's intelligence, but sometimes there's a little bit misunderstanding of what a federal agency is. So we're going to start with that. The federal agency is an actual government entity, and it is within the U.S. executive branch. They are created by Congress to carry out and enforce the law. So Congress, of course, promulgates and passes law, but then there are these federal agencies that enforce those laws. I don't know if any of you know this, but there are currently over 400 federal agencies and sub-agencies. That's a lot, and I just listed a few here just to give you a feel for it. Department of Energy, or the DOE, IRS, United States Postal Service, Equal Opportunity Commission, the Department of Labor, one of the big ones that we will talk about today. There's the U.S. Department of Justice, and there are hundreds more. So there are over 400. And despite its name, DOJ is not a federal agency. It's not one of those. How are federal agencies created and managed? Congress creates these federal agencies through statutes called enabling acts. If you look at 400, since we have 400 of them and the country's about 250 years old, that is quite a few every year. So I suspect that the most have been created in the last 20 years or so, maybe 25 years. And it took a while to get to that level, but we are over 400 now. The president can also initially set up federal agencies through his or her executive orders. Federal agencies, just from the standpoint of who runs what, they generally report to the president. The second piece of this, just to make sure that everyone is aware, what are executive orders? They are rules, regulations, and instructions that have the binding force of law upon the federal agencies, but they don't require approval of the United States Congress. So even though Congress promulgates and passes law, executive orders have a binding force of law on the federal agencies. Executive orders are subject to judicial review and interpretation, however, and I'm sure that many of you are aware that some of that is going on now, and it will probably continue to happen. Just in terms of what the past has brought us, executive orders are not unusual. If you look at Trump through February 21st, so I think we're at the 26th right now. The last time I updated this, we had 73 new executive orders. During the Biden administration, 162. Trump from 17 to 21 had 220, and so on. So they're not unusual, and they do have a binding effect on the federal agencies. So if you look at this, you can see that there is a lot of action at the beginning of each presidential term, because executive actions can and will generally impact changes immediately, or if not sooner. I mean, they're planned, and then there's this rush of executive orders. Just to put this in perspective, however, the most executive orders ever signed was by Franklin Delano Roosevelt, and I think he signed over 2,700 executive orders. So it's not that unusual. It's just seems like a lot. Executive orders can impact employers. A lot of them don't. So if we look at the 73 that are out there right now, or as of a couple of days ago, not all of them impact employment. They impact other areas as well. But some of the labor laws and workplace regulations compliance related to employment can include change in hour or wage and hour standards. These changes can affect overtime rules, the minimum wage for federal contractors, classifications of workers, that sort of thing. Also, OSHA is usually strongly impacted. So changes by executive order can modify workplace safety regulations. You could strengthen or loosen OSHA requirements that private employers have to follow. One of the bigger impacts can be, and probably will be at this point, the impact on union and labor relations. These impacts can influence the ease of unionization, or they can go the other direction depending upon what the executive order says. Can also impact collective bargaining rules, labor dispute resolution, anything associated with union and labor relations. And that labor relations, by the way, does include a lot of issues that are also important to privately held companies. So it's not just those that are under collective bargaining. Also, changes can alter federal contracting requirements. So many employers do contract with the federal government in one way or another. So businesses that work with government, you know, if you have a contract with the federal government in excess of a certain size, you would be subject to affirmative action rules, other types of mandates referred by and through the agencies. And this does include DEI, diversity, equity, and inclusion, different hiring mandates, and benefit requirements. Those are just a few of the things that federal contractor requirements can be impacted. And then we also, because of this, and probably primarily because of this, because of the changes at the federal level, they can also trigger state level changes. States often align with, some will align with federal executive orders, others will align against or in spite of federal executive orders. And of course, that will create additional compliance challenges for businesses. So that is something that's been going on for a while. And frankly, in the last few administrative changes, the states were really busy passing their own laws with or without those changes. And then we've also seen at the local level, extreme number of local level changes that impact employment. Let's start with the administration's labor law related actions and outcomes. the Department of Labor is one of those departments that can, agencies that can impact employment a lot. Just generally looking forward for the, over the next few years, the Department of Labor may be more employer friendly. At least the signals are all there. And we know from the first administration that was 4 years ago that there were many Department of Labor issues that became easier for employers to deal with. In fact, there were many opinion letters that were issued by that or during that administration that eased some of the pressure on employers. And then some of those were flipped back or flipped to even more stringent area after that administration. But there could be potential easier resolution of audits or investigations by the DOL, and the employers may have more opportunities to correct compliance issues before they face penalties. Those are just anticipated outcomes. Also, the overtime exemption changes to salary thresholds. There may be some changes into who qualifies as exempt from overtime pay under the Fair Labor Standards Act. And of course, because of these potential changes, we all need to keep on top of whether we have employee classifications correct and whether something has changed to either make it more stringent for employers in some areas or less stringent. That is still up in the air. A couple of things could also be impacted. So the Department of Labor does have an impact on independent contractor classification. If you work in your business with independent contractors, you probably know that independent contractor status is not favored by the federal government and frankly not by state governments either. So there have been moves in recent years to make it more difficult for people who are working or companies that are working to be classified as independent contractors. There's been a move toward trying to make them classified as W-2 employees, and there are a couple of reasons for that. One of the reasons is that W-2 employees generally, there's a really well-tested methodology of collecting, calculating, and remitting taxes, and that's through the employer. So the employer does all the work. The employer is the one that is subject to penalty and interest and other issues if they don't comply and don't properly handle taxes. Independent contractors are on their own, and some may or may not be completely upfront about what income is subject to taxation. And of course, there can be delays in taxation and collection issues, and independent contractor status is probably harder for the government to manage because they're coming in one by one, as opposed to, if you have an employer with 5,000 employees, they're submitting all of those taxes on, in one file. So independent contractor classification, however, could loosen up a little bit. To me, there's no guarantee that it will, but it could. So there has been a rule that has been put out there so far to look at how much autonomy a worker has over tasks and whether they have the opportunity to earn a profit or incur a loss. So that has been more visited as in terms of qualification of a person as an independent contractor. The Biden administration did not implement the 2020 rule that was put out by the Trump administration, and then they maintained a stricter classification standard for independent contractors. There are already several states that have a much stricter classification rule, so you always need to pay attention to those. But at the federal level, there were tighter regulations when classifying workers. So if we look forward, this rule with a tighter classification may be revisited under the new administration. And there is that potential to return to the Trump era criteria and have a little bit looser interpretation of what constitutes an independent contractor, and therefore provide the opportunity to appropriately classify someone as an independent contractor rather than a W-2 employee. If that Trump era criteria is reinstated, there may be an easier way to classify. However, I would caution everyone to continue to be very careful about classifying individuals as independent contractors, because, and especially at the state level, you want to check what your particular state has in terms of their rules and how much they enforce those rules. Another Department of Labor impact, tip wage updates in the 2018 Trump administration period. They reinstated a rule on tip credits and allowed employees to do more non-tipped work without losing the tip credit. There are many, many states that use the federal tip credit. And the impact was that it was easier for employers to comply. They didn't need to track, was this employee wiping down tables or doing something that did not generate tips for them. But then during the subsequent administration, there was a much stricter 80-20 rule that was implemented and limited non-tipped work to 20% of weekly hours and 30 consecutive minutes per shift. This was very difficult, I believe, for employers to manage, because they would have to literally track tipped employees in 30-minute increments, if not closer than that. So there had been a higher administrative burden and much more litigation over that particular issue. The 80-20 rule, though, before this new administration came in, was overturned. And they did remove the strict hourly limits on the non-tipped work, because there was the assumption or the implication that it was never a part of the Fair Labor Standards Act to begin with. And there was more flexibility in assigning tasks. The DOL rule then reverted to the pre-2021 standards. And I would say that going forward, we probably won't see anything like a return to those more stringent standards. The Department of Labor also engages in looking at employees to see if they are jointly employed. And joint employment is something that's been bounced back and forth between different administrations forever. It is when multiple employers share control over the same employees. There are many situations where that does occur, like fast food franchise. If I own a McDonald's franchise, I may have people who are working between different locations, or I have people who are working for another McDonald's franchise, and it's not even mine. In the past, joint employment has been under pressure, because the idea was that under certain rules, both entities would be held responsible for employment issues, wages, working conditions, etc. This also applies to staffing companies. So staffing companies were really faced with the idea that they were a joint employer every time they staffed a position, and that's very difficult for the staffing industry to handle. The anticipated changes, if they do come about, the new rule may narrow joint employment definitions so that it may no longer apply to the franchise model or apply to similar models. And then it would be more difficult for an employee and worker to claim joint employment, which will bring about less risk to franchisors and businesses who are using subcontractors. In the anticipated changes, if it does change, companies will more clearly be defined as separate entities and not jointly responsible for employment. Unrelated to several other things, we're going to talk just briefly about the federal return to office mandate. The federal return to office mandate does have a potential for impact employers. As everyone knows, I mean, it hasn't been any secret, federal employees were mandated to return to the office, and this shifts some workplace dynamics across industries. Private employers could very well be impacted by this, because more federal workers entering the private job market. I believe, we haven't heard many updated as far as the number between those who have actually come back to the office are out there. And then, of course, there's also the push to eliminate some of the federal jobs, and 77,000 workers have supposedly accepted their early retirement from the government service by September. So those two things can definitely impact those employers who operate in Maryland, Virginia, and DC, although it is said that up to 80% of these positions may work outside of those areas. They may be very close to those areas, though, so that's a primary area to look. There are others, though, as well. There also could be increased competition for talent between the federal and private sector, although it seems that it may go the other direction. If there is a glut of workers in various areas, that, of course, as it always does, impacts the marketability of those employees. So there may be more people out there available and could impact wage levels. One of the other impacts on employers would be anything that the employer is working with and with the federal government in terms of receiving service, including, we have employers who are processing immigration paperwork like H-1Bs, H-2Bs. They process TN visas, the other types of visas that need to be processed, and really primarily the L types and the H-1B. Also, permits, contracts, anything like that could be delayed through federal government just because the employer or the employee shift. The private sector workplace trends, just a potential side effect would be further momentum for return to office policies in private companies. This did start a couple of years ago with a couple of very large companies asking for workers to return to the office. Not a popular thing with people, obviously, but at the same time, there has been some momentum there. And with this return to work through mandate for federal workers, this could further incentivize other companies to do the same. Because of that, too, there may be some renewed investment in office perks, the sort of things that are sitting out there, had been sitting out there for several years, empty cafeterias, empty parking areas, that sort of thing. But those things could come back. Things could change a little bit. One of the biggest issues, of course, is the pause in spending on federal grants and loans. This definitely will have an impact if you are in some types of business. Just to give some scope to this, $3 trillion in federal grants and loans are under review for compliance with the new executive orders. The spending pause was ordered by the Office of Management and Budget. And of course, the funding challenges that have resulted for universities, research institutions, charities, and community projects. And it could force closures or increase debt burdens. The litigation started right away, so that is old news. Nonprofits challenging OMB's funding halt, and of course there are other challenges as well. But one of the things to watch out for is that if you operate a charity or a business that receives federal funding, is that there probably is the need to look at funding sources and possible changes in funding sources in order to mitigate any issues there. But that is very widespread. A couple of other issues that will probably be forefront are impacts on FMLA and paid leave benefits. The federal government is probably very unlikely to try to expand or put in place new mandates for Family Medical Leave Act. For years, there have been expansions of FMLA and paid family and a new mandate, or not mandate, but suggestions and legislative suggestions for adding paid family leave. That it's probably unlikely that those will move forward in the near future. And paid leave tax credits will probably be stayed and not much more happening in that area. And then, as I said, national paid leave, right now, I would say it would be unlikely that would move forward. Employers, though, really have to be cognizant of and track their state laws instead of following one federal standard, because there are many states that are promulgating state paid leave laws, and there are several that already have them in place, but there are others that are presenting and contemplating. So while there may be less, or not less, but no more burden on the Family Medical Leave Act side, and no anticipation immediately of national paid leave, you do have to watch out for the other leave benefits that are out there. The Equal Employment Opportunity Commission is one of the agencies that may end up with some modifications. So there could be a shift toward employer flexibility and reduced oversight. If any of you have ever engaged with the Equal Employment Opportunity Commission through a charge that's been brought through an employee or former employee, there's probably little doubt that is not a neutral agency. So when an employer is charged, there's a significant burden to be able to prove, sometimes prove a negative, prove that you didn't do something as a proof to that you did do something. So in that regard, there may be a more pro-business approach, scaling back the regulations and enforcement, maybe some fewer compliance burdens and less government oversight. Also, the EEOC has litigated when they can, litigated against employers. There could be fewer lawsuits against employers. That shift could be felt immediately. And then that, of course, would lower legal risks and costs for businesses. You may also have some more flexibility in hiring and firing. The Equal Opportunity Employment Commission oversees enforcement of Title VII of the Civil Rights Act, which prohibits discrimination based on race, color, creed, religion, national origin, gender. And then they also oversee the Americans with Disabilities Act, which is one of those acts that has a significant amount of activity brought by employees and former employees, and then of the Age Discrimination Employment Act, among others. So when you're hiring and letting people go, of course, all employers look at what is the law, how does it apply, and sometimes they just can't avoid being challenged by employees. Hopefully there will be some easier workforce management and fewer restrictions, but that will remain to be seen. One of the areas the EEOC gets involved with is background checks and criminal histories. They've weighed in on whether you appropriately conducted a background check or you inappropriately considered something in a person's criminal history, and making sure that it was the particular offense, if any, was related to the job. And so there may be some more flexibility in those hiring decisions related to background checks. One thing you may see swing the other direction is religious freedom and discrimination. There are 2 executive orders out there related to religious freedom in the workplace, or religious freedom, period. So there may be stronger protections for religious beliefs at work. One of those things that there are ready protections under Title VII of the Civil Rights Act. However, there may be increased enforcement and or more executive orders enforcement that ends up being a little bit different than what employers have seen before. There should be some rollback of Biden-era initiatives, possibly less enforcement on discrimination cases, possible changes to DEI policies, and then of EEO1 reporting. For those of you who work in companies of over 100, you're required to do EEO1 reporting to show the number of minorities and females in your workforce. So there could be a shift in not only the reporting itself, but what would be added to that reporting. Nothing would be anything at this point without some discussion of DEI, diversity, equity, and inclusion. The rollbacks in federal policy, there are a couple of key executive orders that came through. 14151, which ends DEI and government and federal funding. So the federal government is eliminating DEI programs in its own agencies and in federally funded institutions. That's very broad. So going back to all these other companies and institutions that are federally funded, like higher education and others. And they also state that all DEI-related grants and contracts have to be canceled within 60 days of that executive order. The new compliance rules for employers, this is a little bit buried, and I'm not sure how many people are aware of this, but federal contractors and grant recipients have to prove their DEI programs comply with anti-discrimination laws. And then inside that executive order, there is the provision for increased federal investigations. And they're saying that the government agencies will launch up to 9 investigations into publicly traded corporations, large nonprofits and foundations, state, local bar and medical associations, and there are a lot of associations out there, and then colleges and universities. So this is a very broad scope, and they're doing the same, saying that they will be looking at whether all of these entities comply with anti-discrimination laws. And so what they're saying is you don't discriminate against anyone at all. And that is what the crux of the matter is. And that could draw some investigation to other entities outside of the federal entities that might be unexpected. As far as an employer, just make sure that you look at if you're a federal contractor and or you have any grants from the federal government, make sure you review compliance and assess potential impacts. Again, it may feel the opposite of what you have been doing in the world at large. A lot of companies the companies that were federal contractors and grant recipients, for the most part, had to assert that they had affirmative action plans, depending upon the size. Those affirmative action plans will need to be examined to make sure that the plan itself, the written plan that you've put out there, does not discriminate in favor of any protected class, including typically non-protected classes. So any class at all. And that, I think that some federal contractors, grant recipients in the past have taken affirmative action to mean that they should push hiring and promotion and that sort of thing to specific people in specific classes. And I think that the takeaway here will be that they will interpret Title VII as it is written, that there is to be no discrimination at all, including in affirmative action plans. So large corporations and institutions, as I said before, could be subject to some new federal investigations. Those employers who are impacted are those with federal contractors or contracts and subcontractors. If you probably know, if your company has a federal subcontract, I believe that there is a lot of reach into the federal subcontractors and knowledge by the federal government of who federal subcontractors are. So I don't think that they will be able to fly under the radar. And then, as was said in the executive order, they will be looking at large publicly traded corporations, large nonprofits, and associations. So associations is a key word, and state and local bar and medical associations. Also, of course, institutions of higher learning, which is they've already taken a look at. Just an example of some of the new guidance on DEI in education. On February 15th, which is just 11 days ago, the Department of Education sent a letter to all schools that receive federal funding. It's called a Dear Colleague Letter, or DCL. It didn't change the law, but it explained the new administration's stance on diversity programs. So the key message was that the federal anti-discrimination laws, Title VI, should be used to limit DEI programs at schools receiving federal funds. And of course, it follows President Trump's executive order in January that told federal agencies to enforce race-neutral policies in school. It does matter for private employers. It does signal that broader shift in federal policy. As I said, it could impact private employers, especially those with government contracts or DEI initiatives. There are many companies out there that have DEI initiatives that are probably will not be in the within the scope, but just to be aware that initiatives and that sort of thing, you want to look at what those initiatives state and what they say that the company will do. Impacted employers are any institution that receives federal funds, of course, and then colleges, K-12, vocational schools, junior colleges, and then occasionally banks too, because banks also have some banks sell some federal items that they will possibly try to draw in and say that banks are also subject to this. A topic that has been discussed a little bit out there is the birthright citizenship. And you might wonder, well, what does that have to do with employment or with my employees? It is an executive order aimed at ending the practice of near universal birthright citizenship. It restricts citizenship and requires U.S. citizenship will not be granted to individuals born in the U.S. if their parents were unlawfully present at the time of birth. The agencies that are tasked with aligning the regulations are Secretary of State, Attorney General, Secretary of Homeland Security, Commissioner of Social Security, and there was a 30-day action requirement. This has been challenged, and I think it will continue to be challenged, but the potential for impact to your business could be if you have employees who are concerned about the birthright citizenship. You may find yourself with people who decide not to stay and maybe leaving the workforce unexpectedly. Labor law changes, union and non-union employees. There was a big shakeup right away. The National Labor Relations Board, the general counsel, Jennifer Abruzzo, was terminated right away in January. And just before, or not just before, but in the recent years, she has issued over 24 memos that really push new interpretations of labor law. And some of them were very controversial and expanded the scope of the National Labor Relations Act. So with Abruzzo's, some of Abruzzo's policies may be reversed under the new administration. A number of them have been rescinded already, and there may be some more employer-friendly NLRB decisions expected going forward. A couple of those possible rollbacks would be the restrictive stances on non-compete and labor rights. Some of the rescinded memoranda, which are utilized by the National Labor Relations Boards, are statutory rights of players at academic institutions. There was kind of a big push to allow them to unionize. An update on efforts to secure full remedies and settlements, electronic monitoring and management of employees interfering with the exercises of Section 7. And then this non-compete agreement that has been rescinded. And there are a few others. There are actually, I have 3 pages of them that have been rescinded, but we won't cover all of them. So there has already been a significant impact. Labor laws and enforcement, there could be some impact on quickie elections, which were something that was put out there during the last administration. Card checks, one of the more popular issues that was put out there, not only at the federal level with the National Labor Relations Act, there was a ban on captive audience speeches limiting employer-mandated meetings regarding unionization. States are passing something similar, but some states, that is. And then misclassification rules, adjustments on how workers are categorized for labor protections. There could be a decrease in filed charges, so we'll have to see how that works out. Hopefully, possibly more employer-friendly settlements, and then a lower litigation risk. Immigration-related actions. Now, this is one of the larger impacts, or the potential impacts to some companies. Some companies will not be impacted at all. But immigration-related actions by governments, and this could be the federal government to begin with, would be the potential for I-9 audits. And of course, the potential for ICE raids, which has been happening already. And then one of the things I think a lot of companies don't think about is the imposition of criminal prosecution, which is allowed under current law. So it's not as if it's new, but also the other part is inclusion of management in fines and prosecution for deliberate hiring and retention of people who are not legally entitled to work in the U.S. I've also heard that there may be a consideration of a mandate to use E-Verify for all employers. I don't know that in the final analysis whether there will be a decision that using E-Verify is effective to begin with. So I think that will be up to interpretation, and we'll have to see how that works. It could actually possibly go the other direction depending upon how the current administration sees the efficacy of E-Verify to begin with. There are some things that are happening that we see out there right now related to actions by employees. So if you have employees out there, we have seen quite a few employees requesting to change Social Security numbers and other identification. And by the way, they can't do that. But we've seen a pretty big push for that from an individual employee standpoint. Of course, no one can change their own Social Security number. The Social Security Administration will, on a very rare occasion, change a Social Security number, but generally that's when a person's Social Security number has been stolen, and there is just no other way to fix the situation because the Social Security Administration can't help to fix it, but that's very rare. We've also seen a number of allegations by non-employees that an employee is using their Social Security number. All this is tied up in the identification and the wanting of people to have their identification in order. And then one of the other things that we're seeing is sharing of Social Security numbers where they may pop up under multiple people. And then an unsolicited submission of new documentation by employees who are saying, hey, here's my new documentation. Every employer has to be very careful about that because you don't want that employee to claim that you demanded new identification or that you asked for it or that you did anything with it. So specifically, you would probably not accept new documentation and not be anxious to take copies of that documentation and put it into employee files, because there is the other side of it where the employee can come back and claim that you over documented them. You may also see in the future, we've seen some absences and then some job sharing between people that has not been anticipated, where we figure out that there are people who are job sharing and they're two different people versus one. You do need to be prepared, I think, for I-9 audits. The ICE audits, of course, everyone knows they were frequent during the first Trump administration. They more than doubled, but I think the audit frequency will be much higher now. And there are likely industries: food processing, agriculture, construction, hotels, restaurants, defense contracting, critical infrastructure. And then potential consequences are civil and criminal fines, as I mentioned on the prior slide, or the 2 slides ago, and then possibly the stop work orders where your business would be told to stop work. The best way to reduce exposure, ensure compliance, is to go back through your I-9s and correct every correctable issue that you have to begin with. If you can correct some issues, that is really positive. It shows that you're trying to be compliant. And just as a side, when I-9 audits go on, if they're, one of the implications is that you may or may not have people working who are not legally entitled to work in the US. But even if the audit does not expose any of that, errors on your I-9s could drive a lot of revenue opportunity. And there are certain things that they look for, and they look for every tiny little thing on an I-9 form, whether it's electronic or paper, and each one of those can result in a cumulative fine. So they fine a dollar amount for this particular issue, another dollar amount for this, a higher dollar amount for that. So the fines can range up to almost $3,000 on a single I-9, and you just don't want to be in that position. Then, of course, there are much higher fines if it's found that there has been some deliberate mismanagement of I-9s and documentation. Workplace raids, everyone probably has seen that Tom Homan, who's the border czar, has initiated some very large-scale raids, and his stated intention is to continue until over 1 million illegal immigrants are deported. Raids are rarer than I-9, but they're very disruptive. And then we really have some of the same I-9 audit targets, but I would throw in defense contracting there as well, because there are some overstayed visas of different types. And there could be some overstayed visas, TNs out of Canada in particular. So if you're in a targeted industry and or you think that you have any issue there, you want to develop a reaction plan ahead of time to minimize any type of downtime for your business. Just situations requiring extra considerations, travel complications. Some people may leave the country and not be able to return. So we're not going to go through much of that. Action items just on this front is audit your I-9s and make corrections wherever you possibly can. Be prepared if USCIS notifies you of an I-9 audit, and then look at your E-Verify setup in case there's a broader requirement to use E-Verify. And if you're in a target industry, prepare for an ICE raid if you happen to be there. And then sketch out a plan with management so people would not be unaware of either an I-9 audit or a raid. You avoid instructing employees on how to behave because the more you instruct, I mean, your own management staff, of course, but other employees, the more you instruct them, it's knowable. And if it is determined that you have deliberately aided people in avoiding looking ICE or USCIS, that could be an issue for the business and the owners and management. And then, of course, read up on penalties, including financial and criminal, for deliberate circumvention of the law. The law really hasn't changed. It's out there. It's the same as it's been before. It's just very much more likely to be enforced. So with that, we're going to pause and see if anyone had any questions about that, any of that material or anything else that we haven't addressed today.
Awesome. Yes. And just a reminder for questions to be asked, please put them in the Q&A question box. We are unable to have you speak them, but we will address them. And Becky, we do have a few questions out there that I will propose to you. One question is if I've already changed my business wage structure on last year's DOL ruling, should I change it again and go back to what it was?
Oh, great question. So that is an option because you can go back to the pre-July 1st, 2024 wage levels for salaried individuals. That's very clear that you can do that. The question of whether you should is probably dependent upon what impact you think it will have on those employees who are impacted. Will you end up driving them out of the company and you don't want to do that? Or is it more of a situation where you feel like you could save some money and it's worth the risk, that sort of thing. But yes, you could return employees to the pre-July 1st mandated excess in set wage and salary. Two other things I'd watch out for, though. One is that make certain that those employees who are salaried, that they're properly designated as salaried in the first place, because you could trigger a reaction from them by doing that. And that reaction could elicit an audit of some sort. And if that position should not have been a salary position in the first place, you may have some risks there. And then secondly, if you're in a state, there's no federal law related to when you have to notify someone of a change in their rate other than prospectively. So you just have to, if today I'm working at a rate of $10 an hour and tomorrow you're going to put me at $5 an hour, I mean, assuming those were acceptable wage rates, then you just have to let me know before I start work tomorrow that I'll be at $5. However, there are a number of states that require you to give a prospective notice. So Nevada in particular requires a 7-day notice before you make a wage change. Minnesota has a 7-day notice. There are several others that have notice and notice in writing. So be careful of that. Up to you whether you decide to revert to those prior levels, though.
Great. Well stated, and that was a good question. Another one I have remote workers. How could changes in federal labor laws affect my businesses with employees working across state lines?
It doesn't really, it shouldn't impact them because right now, the employment law that applies is where they actually work.
Hmm.
So it's not where they live, but it's where they work. So if I work in Wisconsin, but I commute from Minnesota, then I am subject to Wisconsin wage and hour law and all employment law. Federally, if there really aren't, other than the Americans with Disabilities Act, FMLA, those sorts of things, those are all preset anyway. There's not a specific set of employment law associated with those. Those are all federal, so they all apply the same way, no matter where you are, whether people are working in one state or another. It's the state law that you have to be careful of and make sure that you're compliant with where they work, not where they live. So, maybe a next logical question would be, what if they're splitting their time equally? Well, then they are equally subject to, let's say they're half-time in California and half-time in Washington, then you are subject to both law, depending upon how much time they spend in each state. But you would be subject to the law, and that each of those states will contend that you have to be compliant with their state law.
Hmm. Makes sense. Thank you for that. And then last one that I can see as of right now, how could changes to FMLA and paid leaves affect hiring strategies?
Um, well, if I'm not sure, it depends upon, as I said, I don't think there will be any changes to FMLA and paid leave law. But there is paid leave law at the state level, so hiring practices could be based on what state's easiest to work in. Absent, maybe states that don't have paid leave laws, and especially the paid leave laws that are funded by the employer in part, because those just represent additional cost. As far as FMLA, if I can't really speculate on that because I don't see any changes in FMLA. The changes that used to be pending were expanding it, from 12 weeks, a maximum of 12 weeks up to 20 weeks, or to require some other, or impose some other requirements. But that doesn't really impact hiring unless you want to keep under 50 employees and not hire that 51st employee so that you're subject to FMLA.
Yeah,
But you also do want to watch out for state leave law too, because state leave law will sometimes go lower than FMLA, lower than 50.
great. Yeah, and I think also, you could use it to your advantage, and have an edge in attracting and retaining top talent, by making sure you're fully knowledgeable and ready to act on it. So for sure.
Right. Yeah.
Great. Well, that is the questions we needed to address. And hey, I know as we send this recording out and you're kind of digesting on what we went through today, more will arise. And so, with that, we would love to be a resource to answer these questions, any concerns, as well, but also, at advanced staff, we have a lot of opportunities to help businesses, and with this, we really want to help mitigate the legal risk and help our clients and consumers stay compliant with labor laws, and allowing companies to focus on growth and enhancing employee engagement and their overall satisfaction through our HR resources is what we strive to do. So we would be happy to go more in depth and answer any questions that you may have and help you out, with our services. So we definitely, appreciate all the engagement and, jumping on board, and we're especially grateful for Becky today for taking the time to not only address us today but also, prepare such a wonderful a webinar with applicable content for the conditions we're living in today. So with that, we appreciate it, and we thank you all very, very much.
All right. Thanks, everyone. Have a great remainder of your day.